All right, folks. Well, I'm going to call to order the, December meeting for the LADPC, and I appreciate everybody's flexibility with scheduling. We meet monthly to discuss different concerns and issues around alcohol and drug concerns for our community. And we were really feeling the need to pull together some conversations and a place to talk about Measure 110 and what that means for not just the state of Oregon, but Jackson County as well. Today, we're lucky enough to have all of the folks here. You look around our room, we've got physicians, we have a chief of police, we have our district attorney, we have people that are leaders within different elements of our recovery and treatment community. And so I just am kind of marveled at what this room brings together. And so when I get to introduce the Oregon Health Authority's Director of Behavioral Health, Steve Allen, to this group, it excites me because Steve has been very committed to being local in his work, which is really hard to do the more you get pulled into Salem. But as he's continued to visit our community, connect within our community, I'm just always grateful at his availability and his understanding that no matter what happens in Salem, we all live it in our communities. And so, Steve, thank you again for spending some time with us today as we kind of go down this bold new path. And I really want to give you the floor first because I know your time, you are getting pulled some other directions, particularly these days. So thanks for your time today.
So where are we? So this measure, I think, as everyone knows, decriminalizes minor possession. About 4,000 people in 2019 were affected by this. There's a disproportionality with blacks being caught up in this at twice the level. But we're looking beyond just the immediate impacts of this, but am also anxious to hear from the district attorney, the courts, law enforcement about how you perceive this, what your concerns are, and frankly, what you think an array of services would be that would truly help support the individuals affected by this so that they're not caught up in the revolving door of arrests and jail and treatment, et cetera. So what can we do together to support each other in doing this work? But the measure decriminalizes, as I mentioned, it moves marijuana money from where it's been, chunks of it, to a special fund to help support this work. That includes creating a temporary hole in OHA that I've been assured will be backfilled. How the money will flow, when it'll flow, I think is all up in the air. The governor needs to weigh in, the legislature needs to weigh in about how this will be distributed. But there are a few things that are coming at us pretty fast. One of those is standing up an oversight council that will help shape the services. Is currently designed to authorize grants that would go to local communities. We're busy recruiting for that. There's a website now on the OHA website where you can provide input. You can also volunteer to be part of that council. So we are looking for people to help inform this, and I've already been in a number of different meetings by a number of different groups who have a strong interest in this work and are eager to help shape it in ways that they think would be most beneficial for people in Oregon. The second is to stand up a temporary crisis line where people who are cited for this and have the $100 fine can call in and check in, be assessed, and receive services. That work is moving forward. We think Lines for Life is a logical place to put that initially, at least, because of the other book of business that they're doing for us right now, so that makes an easy transition. And then beyond that, those two things then is the beginning to design the services and begin to look at what's termed an addiction recovery center that would be part of a regional array. I think in my mind, there's lots of flexibility on how to build that. It doesn't necessarily have to be the same thing in the same place around the state, which is where I think we need a lot of regional input on what that ought to look like.
Lori, I kind of feel like the natural segue might be to your part of this conversation, if you're ready, just in terms of the group you're involved with and the work you're doing, to give us another kind of statewide perspective. And obviously, you know darn well what it could or couldn't look like in our community, or you have an idea about it at least. So if you don't mind, I'd like to kick it over.
Sure. And just keeping in mind what Director Allen was talking about, it's in its very early stages, so there's still a lot to be fleshed out. So the work is in process. There are a number of elements spelled out in the law for service elements that are expected to be part of this effort, with funding administered through a grant application mechanism at OHA, 2 providers who meet certain requirements, so everybody has to apply. There's no funding that's committed or promised to any particular providers or groups, but the door is wide open. So that flexibility that was spoken about earlier is really true. So it's not just the existing substance use disorder and mental health providers. It's also organizations that do housing, that do peer organizations like Reclaiming Lives. Potentially there's lots. So there's a lot in there, and more information to come. Oregon Health Authority is charged, with an implementation responsibility and also the communications around this going forward. So that's how we'll hear about it as it goes on.
So that's adult community justice, but I wanted to kind of kick it over to Joe Ferguson to talk about juvenile work. One of the stories we heard was that if a 16-year-old was at a party and they had a wine spritzer or a wine cooler in their hand, there would be a system response where that would be referred to court. That person would have to then engage in some preliminary treatment services, and that MIP would kind of channel a number of different services with some accountability on the back end. But if they threw away that wine cooler and said, no, it's just heroin, they would get $100 a ticket and no call to the parents that we know of yet. So I throw that out there as my cautionary tale, but I know Joe and Beth are working around different responses to what that could look like, but I'll kick that over to you, Joe, to talk about initially.
Sure. So, I think everybody's aware that this measure, youth were not a concept even looking at when this was going through. And so it's really an afterthought now of what do we do with youth. And so, as Eric mentioned, I reached out to Beth. We currently, for violations that could potentially go to immunity court or justice court, we have a waiver in place. So those MIPs of alcohol and marijuana currently all come to the juvenile department. So we can track those. We can be consistent in terms of services. And so we're looking at pretty much the same thing. So in terms of those new violations, still coming through one place in terms of juvenile, even though we can't do a whole lot with those. One of the big concerns is a youth could be cited, parents would never know because it goes to municipal court or justice court, or a kid that's on probation. The probation officer may never know because that may never come to us. So that's one way of kind of at least helping us track them and still provide some level of service. We're kind of looking at handling the same as we do with the MIPs currently. So we would provide a diversion for the first one. So in lieu of the fine, if they do the health assessment, then we kind of track that. If they continue to come back for other ones, then they would get the fine. The mention that Eric did on the MIP of alcohol, so if a youth is cited for MIP of alcohol, and they go to court, it is a automatic license suspension and at least a $350 fine, up to a $1,000 fine. If it's marijuana, it's a license suspension and $650 fine, up to a $1,000 fine. So they're getting punished more for alcohol and marijuana than they are for a harder drug, and that's concerning in terms of what those drugs could do to kids. On the juvenile side, we do the same thing that the adult side does in terms of risk assessments. We are based on all of our service on the higher risk kids. And so even though a youth may come in on a misdemeanor drug offense currently, they could be high risk. And so we're going to dump a lot of services into that youth. If they're a lower risk kid, then no. Even if we do a risk assessment on those violations, there are no services that, technically we can provide if they aren't willing to participate. And that's one of the things I think concerns us with youth, is that they're not real amenable to treatment. They think that it's fun. And so that takes away one piece of accountability that we had. On the statewide level, Oregon Juvenile Departments Directors Association, we have a committee that's being put together in terms of talking about this and kind of what each county around the state's doing and kind of what we've heard. So I was on that earlier before coming onto this one. And so, it's being talked about both locally and at a statewide level still for youth too.
Beth, one of the things that I've heard, and that has crossover into prosecution, is, well, what will this do to drug court? Are there still folks that will benefit from drug court? And what will this do to prison? And my answer, and again, I hope you correct me refine my answer much the way Joe has, but my answer is that, drug court really hasn't been taking cases that are just PCS for quite a while. They're taking cases that are prison eligible. And so that person gets to do drug court in lieu of a prison sentence, and they usually have prison as a consequence should they not be successful in drug court. And then the secondary piece was that, these PCS cases weren't landing people in prison on their own. They didn't have that kind of drive or sentence capability. But I don't want to misspeak on that. So as I kick it over to you, if you could make sure that I'm correct in my answers. But Beth Heckert, our district attorney, thanks.
Thank you. No, you're correct. So around the state, some drug courts might be more affected by this change of legislation than they would be in Jackson County. We, for many, many years, have not seen people go to drug court for a possession of controlled substance. And the only exception for that would be like a professional person who was in danger of losing their license or something. If they were to get a conviction, they would take advantage sometimes of that opportunity. So we had people who we put on conditional discharges, and then if they weren't doing well on conditional discharges, they were transitioned into a drug court. So that avenue, I guess, of getting there is gone. But no one is going to prison for PCSs and has not for a very, very long time under Oregon law, clear back to 95 or longer. So nobody's going to prison on PCSs. And this is a big change, and we'll kind of see. I also wasn't in favor of it, but now that it's the law, we're going to do our best to, abide by it and see where it takes us. But it's still going to be a crime to possess what was felony quantities are now going to be misdemeanors. So if someone has 2 grams or more of cocaine or methamphetamine, that's going to be a misdemeanor now. So it's not like all possession is just a free-for-all, you can have whatever you want. It's not quite there. 40 or more user units of LSD, if you have 40 or more, it'll be a misdemeanor. If you have 12 grams or more of psilocybin, if you have 40 or more pills, tablets, capsules of oxycodone, that'll all be a misdemeanor.